what the International Registry is and why it matters. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with the first and most important point about the International Registry of Mobile Assets as it applies to aircraft. This is not merely an electronic filing system. It is a priority system built to follow high-value aircraft assets across borders. At the treaty level, the starting point is the Cape Town Convention and the Aircraft Protocol. In the United States, the implementing framework appears in the Cape Town Treaty Implementation Act. 49 U.S.C. Section 44113 and FAA regulations include 14 C.F.R. Part 49. The FAA explains the central idea directly. The International Registry is an additional place for the filing of interests, including prospective interests in certain airframes, helicopters, and aircraft engines. That word additional, with emphasis, matters. The International Registry does not simply replace domestic title and recordation practice. In the United States, you still care deeply about the FAA registry. But for eligible aircraft objects, the International Registry is where the treaty priority is won or lost. The Aircraft Protocol defines which aircraft objects qualify. Broadly speaking, the system applies to airframes large enough to carry at least 8 persons, including crew, or goods in excess of 2,750 kilograms, helicopters large enough to carry at least 5 persons, including crew, or goods in excess of 450 kilograms, and engines meeting the treaty threshold for turbine and piston engines. That threshold is 550 rated takeoff shaft horsepower. For jet engines, it's at least 1,750 pounds of thrust. That means many business aircraft transactions are inside or subject to the International Registry. A large cabin Gulfstream, Bombardier, Dassault, Embraer transaction may well be a Cape Town transaction. So may the financing of a qualified turbine engine, even apart from the airframe. The convention also tells us what kind of interests matter. Under Article 2, an international interest can arise from a security agreement, a title reservation agreement, or a leasing agreement. Under the Aircraft Protocol, contracts of sale and prospective sales can also be registered. This is one of the reasons the treaty has become so important in private aviation closings. It addresses not only lender security, but also title protection, as well as sale priority. Now, here is where owners and even some advisors make costly mistakes. They assume registration creates the right. It doesn't. It does not create that right. The International Registry itself warns that registrations merely provide notice, and that the underlying facts determine whether the interest falls within the scope of the convention and protocol. In plain English, a bad transaction does not become a good transaction because someone clicked register. That is why the formal requirements still matter. Article 7 requires a writing, power to dispose of the object, and a description sufficient to identify the aircraft object. The Aircraft Protocol says manufacturer's name, model designation, and serial number are necessary and sufficient to identify the object. In practice, that means serial number discipline is not clerical housekeeping. It is legal infrastructure. A real-world perspective helps here. Before Cape Town, aircraft creditors often relied on domestic recording regimes and general commercial law concepts to protect moving assets. Cases such as Enri Western Pacific Airlines show the financing world that disputes over perfection and competing rights in aircraft equipment could become expensive, technical, and insolvency driven very quickly. Cape Town was designed to reduce exactly that kind of uncertainty for mobile aviation assets. And here's a point to remember. The International Registry is not paperwork, it is a priority architecture. For private aircraft owners, that means the registry should be viewed as part of the acquisition strategy from the beginning, not as a closing room afterthought. Council must decide whether the transaction creates an international interest, whether a prospective interest should be filed before funding, whether a contract of sale should be registered, whether an engine filing is also required, and whether the domestic recordation package is aligned with the treaty registration plan. In short, the International Registry matters because aircraft move, capital moves, and disputes cross borders. Cape Town gives the market a common priority language, but it works only when the transaction documents, the serial numbers, the filing strategy, and the closing execution are all lined up. Here's the takeaway. Remember this: in aircraft finance and ownership, the International Registry does not just record the deal, it helps determine whose deal survives. Thank you for your interest in this topic. This information is provided for informational purposes only. It should not be construed as legal advice. Questions are always welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate your aviation-related legal needs with precision.